And now, it's The Law Show on CL 650. A comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
And my last will and testament will finally read this way.
Welcome to The Law Show. Good morning. Nice to have you with us here on CIL 650. On the program today, we are joined by John Lakes and John White, partners at Lakes White LLP, a North Vancouver law firm experienced in the entire estate planning and estate litigation category. And on the program today, we're focusing on matters affecting spouses and children. John Lakes and John White, welcome back to The Law Show. It's always good to have you aboard on a Sunday morning.
Nice to be here.
Well, thank you for having us.
John Lakes, as the senior partner in this outfit, tell us a little bit about the firm. You're a North Shore guy, went to the now defunct Delbrook Senior Secondary,
That's right.
a UBC law grad, and basically a homeboy who's never really left home turf.
Well, I left a bit, but my claim to fame is I was at the Highlands Riot in 1966.
Oh, okay.
Which is, I guess we've just passed its 49th anniversary.
That's right.
So maybe they should have a 50th reunion.
Well, you know, you can feel one coming almost now.
Well, there's a lot of people here who remember that, not so fondly, but it was our rock and roll year in the village.
That's right. That's right. It was. And now, how long have you been practicing law in North Vancouver?
I've been practicing law since 1981 in North Van, and I've had my own firm since 1986. So we're now, with some of our clients, we're getting a second or even third generation of people that we've been serving.
Isn't that nice? When you get that, well, Mom and Dad said, we've got to come to you to see you because you did such a great job for them. Well, you can't get any better recommendation than that, can you?
No, it's the returning client is always the key.
Right. John White is also a North Shore guy, but unlike his partner here, spent a little bit of time out of province at law school, and of all places, the University of Toronto, which hasn't hurt your career one little bit, has it?
Well, I don't think so. I enjoyed it out there. It was fun while it lasted, but I really had no intention of staying out there. I wanted to come back to Vancouver and practice law here.
Right.
And so I practiced downtown for about 7 years. And then I moved back to the North Shore in 1999, and I've been practicing there ever since.
Right. And the workload in terms of the barrister solicitor thing, this is a lawyer thing that, you know, we see the ads in the paper, you know, so-and-so attorney at law, and that's American. We say lawyer, a barrister and solicitor. The barrister is the guy who goes to court, John White. That would be your primary duty, right?
That's right. In England, which is where we get so many of our terms, you have people who are exclusively barristers and only licensed to be barristers. You've got other people who are licensed to be solicitors, and they work up the case, and then they hand it off to the barrister, who then takes it into court and argues it.
Right.
Here in British Columbia, every lawyer is a barrister and a solicitor. We can do all of the things that barristers and all of the things that solicitors can do. As it happens in our firm, John Lakes acts as the solicitor. He stays in the office. He meets with clients. He drafts documents, drafts wills.
Right.
I tend to do the court work like a barrister does.
Right. Now, John Lakes, you do make the odd appearance in court, but usually in the context of being a witness in some case, don't you?
Well, either that, I'll do some uncontested matters. Sometimes there's probate matters or things like committeeships where you have to get a court order, but nobody's really arguing over the point.
Okay.
But I don't get to the point where you have trials or anything like that. It's a personal choice. I did it many years ago, but it's not everybody's thing.
Well, I understand that. And on the program today, we're going to talk about spouses and children. And it seems, you know, when I was first made aware of the idea that we should talk about spouses and children, I thought, well, why in the context of wills and estates? But, you know, even just getting to the legal definition of spouses and children, as I discovered over coffee with my guests, my gosh, you talk hours just over legal definitions of same. So John Lakes, start us off. Let's start talking about spouses, and we'll see if we can get to children within this hour. Talk to us about the legal definition of spouses, especially in a wills context.
Well, the whole obligation to spouses and children are almost the fundamental obligation you have in a will.
All right.
And so right in the act, it starts off with fundamental rules. Rule number 1, or how do you define a spouse? So in the Act, a spouse is two persons or spouses of each other for the purpose of the Act. A, if they were married to each other, or B, they lived with each other in a marriage-like relationship for at least 2 years. But people should realize that the being legally married and marriage-like relationship is quite distinct. So, first of all, if you're legally married, there's a presumption the marriage is a valid marriage unless you can challenge on basis of capacity if the person wasn't capable at the time they got married,
right,
or is based on fraud. But it's very difficult to challenge a valid marriage.
Right, okay.
So as long as you have not gone through a divorce, or what's defined as Part 5 of the Family Law Act, which is a court procedure where a court has deemed that the couple is now legally separated.
Okay.
You are still a spouse under the Act. So you could have a couple that have lived separate and apart for 20 years, but they've never bothered getting a divorce.
So technically they're still married.
And they've never done anything. They still are spouses.
Right, okay.
And so the court has also taken that in consideration because in British Columbia, believe it or not, you can have 2 or more spouses entitled to your spousal share of an estate. So the problem
is... Okay, just hold on now. I'm going to stop you right there because this is the first I've heard of this. You can have more... In British Columbia law, you're allowed more than one spouse?
That's correct.
Under what conditions, Mr.
Well,
Lynch?
I'll give you 2 examples. So first of all, you could have somebody who's married to somebody they haven't lived with for 20 years, but they've never bothered doing anything to terminate that relationship.
Okay.
And they could also have now also lived with somebody else in a marriage-like relationship for more than 2 years. So they have both a legal spouse and a common law spouse.
Ah.
And that is more common than you'd think.
So in the eyes of the law, that guy has 2 wives.
Yes. Or else the other situation is you could have somebody living with more than one spouse under their roof. And it does happen where you could have someone having relationships with 2 people and they all share the house together.
Mm.
And that's, that you see the Sister Wives case in the TV series, that would be...
That's right, like Big Love.
They would all have legal rights in British Columbia.
Isn't that interesting?
I don't believe there's any cases on it yet, but it's I did have somebody like that situation, but then both her husband and her common law spouse both died, so that was the end of that problem.
But in terms of the legally married spouse, does that person enjoy, John White, any more privileges or recognition in law than the common law spouse?
Well, in terms of wills variations and rights to property when there is no will, basically you've got to be a spouse. But spouse, as you've heard John say, is defined in a couple of different ways.
Right.
And the intention of the legislature appears to have been to reflect societal reality, which is that not every couple by any means is legally married, and a lot of couples aren't interested in being legally married. Right. So strictly speaking, those rights are the same. But I guess where the distinction could be drawn is how you basically get out of one of these relationships. As John had, I think, touched upon, with a legally married spouse, there's a fairly cut and dried procedure involving a divorce, or at least a decree under
a finalization,
right? Under,
formula, finalization.
Right, under Part 5 of the Family Relations Act. That's all pretty definable,
right?
But all the Wills, Estates, and Succession Act, or WESA as we like to call it, says about ending a marriage-like relationship is that it ends.
Okay.
But I just want to go back to the marriage situation.
Okay.
Because the marriage is very... People think being common law and being married is the same, and it's not true.
And that's what I was just asking about.
Yeah, so I just want to go back. So if you're married to somebody and you're no longer married to that person, first of all, if you haven't changed your will and you've got a divorce or Part 5 declaration, then it's when you die, it's treated as if your spouse, even if they're named in the will, has predeceased you, so they're not a beneficiary. So if people got all their act together where they've got a divorce, they got a Part 5 matter, they're okay. But there's a period where people are not okay. So that's why as soon as somebody goes through a legal separation, or a separation, I shouldn't say a separation with their legally married spouse, they better do a new will right away.
Okay.
Because they're going to be in that gray area, because that person may have the rights, but they may do a will saying, I've separated from so-and-so, we've divided our assets, I don't want her to get anything.
Okay.
But but the rights of a legally married person is much higher than the rights of a common law couple.
Okay.
And
how does that get demonstrated in law, John?
Because the problem with a common law situation is that you have to live together in a marriage-like relationship for at least 2 years.
Okay.
And the difference being married is most people know the day they got married. However, a lot of people, when they're in a common law, they don't always have a clear date, because when does the overnight dates end up becoming a relationship? So George may think they've been living together since the 1st of June 2014,
right,
while Mary thinks they've been living together since 2011. So there's an issue, when did the 2-year period start running? Because if the person's died and you've only been together for 15 months, you've got no rights as a spouse.
Oh, really?
As opposed to when you get married, your rights start from the day you get married.
That's right. Okay. So that's one of the big differences, John White, that you were talking about.
Yes, and that's fair enough. I mean, once you make it to the 2 years, and once you are a spouse, the distinctions really aren't.
So it's under 2 years where you're in a kind of a limbo, a definable situation where the law is not going to be your best friend.
Well, it's not even really a limbo. You're not a spouse.
Okay.
If you have to be in the marriage-like relationship for 2 years.
Did not know that.
And if it's only 15 months, you're not a spouse.
Okay. And so in terms of the Wills Estates Succession Act, or WESA, as you like to call it,
right?
The Act states, John Lakes, that the person who has died has a moral obligation to his or her immediate family first and foremost. Is that not the case?
Yes, it is. But there's another big problem with WESA, and that is how you terminate the relationship. So if you're legally married, you have to get a divorce or a Part 5 declaration. But the problem with WESA, and I've written many times to the government, I've had a lot of help from Jane Thornthwaite, the MLA, but we haven't got anywhere so far, is in WESA it says in the case of a marriage-like relationship, one or both persons can terminate the relationship.
Right.
And so you could have a situation where maybe a man and a woman have lived together for 40 years, and the woman goes into a care home, and the man's then taken by his daughter down to a notary's office, and he signs a declaration, I no longer live with Mary.
Mm-hmm.
We're no longer in a marriage-like relationship. And technically, Mary would have no rights as a spouse. She might have rights under constructive trust, but the point is you don't. There's virtually no protection for a common law spouse under will when their relationship is terminated, and secondly, the relationship can be unilateral as well.
So how then, John, you're the one that draws up most of the wills. John White goes and scraps over them in court. But when you're drawing up a will, what sort of language do you use to help your clients when you know this is a possibility, when there's a common law client who may have someone walk out and declare the relationship over after umpteen years and be just fresh out of luck?
Well, sometimes there is no protection because you're seeing them when they're all together. If they've separated, they have other remedies themselves under the Family Law Act, but it's sometimes there's not much of a remedy, because what will happen is, maybe all the assets are in one person's name. And
that's not too rare.
I mean, personally, I think this provision of the Act is very unfair, and I don't understand why feminists haven't raised heck about it, because There's a lawyer. I've written to the government. I've had some help with Jane Thortwaite. The government's never changed it. The NDP caucus has never shown any interest in this topic. There's a lawyer in Kamloops, Kimberley, who deals with it too, but it's still sitting there. And personally, I think to make it, because the other spouse could even be mentally incompetent. And it's when you get into this whole situation when somebody is no longer living together because of some healthcare issues,
right,
whether it's a true separation, which is another story, but it's just so it's a warning to anybody in a common law relationship that this could come and hit them like a bus, and they may not even know what happens.
That's why it's so important to check out the Law Show here on Sunday mornings on CIL 650. There are important little nuggets in each and every program we do. And John Lakes, that was an important little factoid that you just, I'll get you to remind us of that when we return. And we'll take a quick break first and foremost here on CIL 650.
Okay. There's more of the show still ahead. This is The Law Show on CIL 650.